In a world where technology evolves faster than we can keep up, where every need is just a tap away, we rarely pause to ask, what does this mean for relationships between organizations, their employees, and customers? Would you share your phone number with a stranger, invite them into your home, or accept a cookie from someone you don't know? I suspect your answer is a resounding no. So why is it acceptable when our data gets leaked, an unvetted employee is hired, or when we are forced to accept cookies we don't understand? Hi, I am Ashok Hariharan, CEO of IDfy, and this is the Trust and Privacy podcast, where we explore what trust means in a digital-first world and how to build it. Each episode, we will tackle the hurdles industries face in earning customer trust with insights from experts who have been on the front lines of this journey towards transparency and confidence. For our first episode, I'm thrilled to welcome Supratim Chakraborty, a partner at Khaitan Co, recognized by Economic Times 40 under 40 for his groundbreaking contributions to data privacy law in India. Supratim has been instrumental in shaping the upcoming DPDP rules, making him the perfect guest to launch this conversation. We'll dive into pressing issues like data privacy in rural India, simplifying consent for diverse audiences, and much more. Curious? Let's get started. Welcome, Supratim.
Thank you so much.
And we have known each other for about a year and a half or so. And for me, as we talked about it, is for me privacy is like something which I kind of I almost felt like the reason I was excited about it is that my data is being misused quite a bit. Everybody seems to have our data, and people sell our data. We kind of, without my permission, sometimes with assumed permission, sometimes with these clauses which are onerous if at best, and probably criminal at worst. But in that sense, what is your story? Why privacy? What drove you here?
Right, very interesting actually. When I joined my first job, this was a law firm which used to do work for a lot of tech giants, okay? And I got my first exposure of people asking questions around data privacy and protection. Now, this is 16 years back. India hardly had any provision of law, and therefore it made me think that, okay, why are we in India not serious about it? The other thing which I observed is this huge divide that is there between, say, a tier 1, tier 2 and other cities, right? Mm-hmm. Where the level of digitization and the level of understanding, a penetration of internet, and how they perceive privacy versus how we are now understanding privacy, okay? We need to bridge that gap, okay? Mm-hmm. So that was the excitement that I had in mind and got started. Slowly, I started realizing that, okay, internationally and domestically, the regulators and even the players, the business players are becoming more serious about it. You would observe some players are now thumping the table and actually making privacy a business differentiator, right?
Yes.
So that is where I got a lot of excitement, okay, that we need to do something about it, where it will not be seen as a negative. Usually, in India, you will see people will come to you, and they had come to us as well, stating that if I don't have to follow this law, please tell me what to do, rather than tell me how do I become compliant with the law. So interestingly, so what I started thinking is, can we do something so that it becomes a positive, rather than a negative, okay? So I've been extensively speaking, teaching,
correct,
wanted to take this down to the root level for the last person on the floor to know that how this can also be a positive and not just a tick in the box in compliance.
Yeah. So yeah, I mean, interesting thing, right? Because if you think about the what I would call India and Bharat divide, for us, we, at least at some level, maybe for a lot of us, we even in the India part of India, we don't, as citizens, we don't necessarily take privacy seriously, right? We are very free about giving permission for everything and kind of sharing our data. And if I were to think about Bharat, how much
how much worse is it going to be for them, right? Like how do we educate the folks that they should be careful about their data is a question I've always had, but
Yeah. No, I think great question. And in India, that's why we need to Indianize our data protection law. We cannot simply ape the foreign regulations and say that, okay, we have done a great job. We have a lot of local nuances to look into. Okay. I'll give you a simple example. In an urban household, probably a kid, whether below 18, around 18, would have, say, another phone at hand, right?
yeah,
In a rural household, possibly, you could have that same phone being used by multiple people.
correct.
Okay. So when we talk about verifiable parental consent, just as an example,
Correct.
it will be so mixed up, right?
Correct.
So therefore, when we talk about India and Bharat, the divide is definitely there, and we have to accept it. I think the best part is sooner we accept it, the better it is, because we will then think of solutions accordingly, not be in our own castles and try to build laws for the big tech,
Yeah.
right? Laws for the cities.
Yeah.
This should be law for everyone, to the last person.
That's interesting, right? Because for DPDP, it's a principle-based law. Like if you and that's what I realized, right? We don't call them data subjects; we call them data principles. At a very core, we are treating people with that it is their data, not they're not a subject to a fiduciary. So I think that was itself is a big difference between how we are thinking about it versus the GDPR world.
Oh, absolutely, absolutely. I completely agree. And if you see, probably that is the reason we recalibrated.
Yeah.
Right? We moved on from a pure GDPR type model, or largely leaning towards a GDPR model, to something that we wanted to create for ourselves.
Yeah.
Okay, that's why it's more principles based, some rules based. Therefore, the point was that there was more liberty, which was thought to be given to the industry, so that they can lap it up more responsibly. And therefore, the bright line test would be that, did you put yourself in the shoes of a data subject, a data principal,
Correct.
and look at this entire set of regulations, rather than just simply, again, trying to tick the box.
Correct.
However, I must also flag out one problem area. Okay, when you try to do a lot of principles based drafting of law, what happens is a lot is left to the adjudicators.
Correct.
Okay, and over time you could have different people, different regulators, different people who are
Yeah.
sitting in judgment deciding differently
Correct.
on the same thing.
Correct.
And therefore, there will be piling up of judicial precedents. That is what will determine how a particular provision of law is to be looked into. Right? I'll give you another nuance, which is again very interesting. When you read a provision, probably of law, there could be some positive things to be done, there are some negative things to be done. Positive things to be done, if you leave it broad brushed, it's still okay.
Yeah.
Because people can choose versus A solution versus B
Correct.
solution versus C
Correct.
solution. If you keep the negative part of it broad brushed, the problem is it will only help the regulator and authority,
Yeah.
who can come knocking at your door and say, listen, I thought it was not right.
Correct. Correct.
So therefore, what you'll have to be cognizant of is take a middle of the road approach. Now that we have this avenue for rules, this law should be ideally calibrated as a principle based and rule based, not leaning heavily on either side.
How will that work in reality? Because now you'll have the 4 regulators: the tribe, RBI, SEBI, and DPB, which will get created. Each of them will have their own interpretation of this law, and the rules might. And incidentally, specifically our with DPDP, the regulator might decide his own. Regulators' rules can supersede the DPDP rules. So how do you think it'll play out, or what are your thoughts around?
See, the way I would look at it is, of course, the Data Protection Board would look into the digital personal data aspect of it.
Yeah.
At the same time, it will cut across. It has to. Okay. For example, if you see there's a lot of regulations around intermediaries, which is platforms,
Correct.
what they are supposed to show to kids, what they are not supposed to, and then you have this verifiable parental consent, right? If you look at it, this data protection board is supposed to look at the data angle only. But when the conversation begins, it would easily meander towards, okay, what was shown to that kid
Yeah.
after that data consent was taken?
Correct.
So it is not going to operate in silos. Talking about regulators, right? If you look at it today, we have to go to CERT-in, Computer Emergency Response Team of India, within 6 hours of either observing a cyber incident or being brought to notice. Once the data protection board is formed and this law comes into play, you will have a requirement to also go to the data protection board and also to individuals that, listen, there's been a breach. It is going to be more cumbersome going forward. And if there is a sector regulator, then of course that gets added and all of that. If you look at it, it can be easily simplified if the regulators want to streamline this. There are certain jurisdictions where you report with just one form, and behind the interface, the relevant regulators will all get the same information. So in our case, it could be, say, a CERT-in, a data protection board, and RBI, if it's sector regulated, say a fintech company or whatever. It should be one submission.
Yeah.
In a bad day, when I'm trying to contain a breach, if you are asking me to first prepare a form for CERT-in,
Correct.
then one for data
Correct.
protection board, then one for individuals reporting, which is the most dangerous one, by the way, because when you do blast mailing to all individuals who could be impacted,
Correct.
you will at least get 25% of those people writing back to you.
Correct.
And you have to attend to that.
Correct.
So your entire energy has suddenly gotten channelized from containing the breach, understanding what is going wrong, to attending
explanation.
to all
Yeah.
of this, right?
Yeah.
So the way forward, the best way forward could be that if the regulators can speak amongst themselves, and if there can be a streamlining of some of these processes. There was one provision which was there in one of the earlier versions of the DPDP Act, which says that there would be MOU, understanding between relevant regulators. Okay. To my mind, whether you write it or not as an MOU, it really doesn't matter. But if they are speaking to each other and trying to really have a assimilated approach, a single window approach for the businesses, that will be the best thing for India.
Yeah. Yeah. I mean, it kind of when I'm talking to these fiduciaries, and one of the things that everybody kind of talks about is the cost. What is the impact of all of this? Now we're going to have to create a completely separate team managing incident response, to manage consent tracking. There needs to now everybody in your company needs to now be trained on DPDP and the impact of DPDP, because I don't think people thought privacy at all. So there's some Excel sheet somewhere sitting in companies, in somebody's desk with all the customers' names and what they've and their numbers and what they've bought from them, and probably easily sellable as well. How are your clients thinking about these things, right? Like, is it bothering them? Is like what the question? I mean, I have a question here, but I'm going to change that. The question I had is this something that you can think about as a cost, or is it something that you can create as a trust and therefore probably increase value? But more importantly, does this give unfair advantage to larger companies than smaller companies? Because
okay, good question. But before that, I just thought of this example when you were mentioning about how there could be an Excel sheet lying somewhere, right? I remember in one of my previous organizations, when anyone new used to join, the CV that the person would have submitted at the time of applying for the job used to be circulated to the entire organization, stating, "Welcome, so and so, and here is the CV. Feel free to sort of reach out, etc." And that had got everything. Home address, mobile number, blood group. Does the entire organization need to know about it? Answer is no, right? The good part is, though, that I think the mindset is changing, at least in, I would say, mid-sized to large organizations, definitely. To some extent, even smaller organizations who are data heavy or looking into data interfaces as a part of business. Um, is it going to favor one over the other? It depends, okay, how you're looking at it. Some of the smaller organizations could be lighter on data, and therefore it could be an easier fix for them
Yeah.
as compared to larger organizations, right? But I think it's responsibility of all. It will be incorrect to say that there will be no cost attached.
Correct.
There will be cost attached, but is there a better, smarter way of approaching it? Yes, there is. Some people, we were discussing that, you will go into a whole hog exercise of doing data mapping, data inventorization, which is sometimes taking a lot more time
Yeah.
and effort and money and everything. Is there a parallel mechanism? Is there another way of looking at it? That's important. The first piece is important. But other things like policies and processes, can I also look at that?
Yeah.
What is there in play?
Correct.
What are those low hanging fruits which my people in immediate proximity of the data can easily understand and put into play?
Correct.
These are things I think we should do smartly in order to ensure that there are small wins for these teams.
Yep.
And then they do larger exercise and become
Correct.
more mature,
Correct.
and therefore this really becomes a reality and not again a tick the box.
So like, on that note, like one of the things that we have been telling a lot of our clients is, that the data inventory, data asset management, all of this is a long drawn out process. It can take 5 years and it never ends. It keeps going on because you're going to have new scenarios coming up and where does your data sit is like where is God? Can I see God? At some level it becomes a religious exercise rather than a exercise in reality, right? So while you do that, and you have to find your moksha and nirvana, and the path for nirvana exists, and I do find data discovery as a path to nirvana, but it doesn't happen overnight, right? So we were thinking, okay, what are those small things you can do, right? One was just get your consent proper, right?
Yeah.
And for the flow, and so we look at it as flow, stock, and data as 3 separate problems. Get your flow right. You can audit all your journeys. Number one, get that out of the way. It's simple. It can be done overnight, not overnight maybe, but like within a few weeks. And then you go to stock, again, solve the problem of consent. And then you go to processor management, which is again, relatively, you can map all your processors, map the data to the processor. While you're going through this massive exercise of data discovery, data mapping, data inventory, which, it just seems like a lot of fiduciaries are thinking that that's where you start and then you go to consent. I actually think it's the other way around. Start with the simple things, solve the problem for flow, eventually stock will get solved. I don't know what's your...
No, I think this is a great way of looking at it because sometimes organizations get discouraged.
Correct.
We have seen so many of them who, in their inventorization process, midway have lost steam.
Correct.
Therefore, I also look at it, this is a human way of approaching the subject.
Correct.
We have to encourage people, we have to excite them.
Correct.
In each of the business functions, and I keep telling this, okay, you cannot have like legal team and IT team is leading. No, that will not happen.
Exactly.
Get the privacy champions or whatever nomenclature you want to use in each of the functions. At times there have been cases where someone not so senior in an HR team talk to us that, listen, there is some personal information related elements which is there in a file which no one has talked about.
Yeah.
So when you do this, the other way of approaching that we talked about, I think it's a better and more human way of looking at it, exciting people.
Correct.
Let's do this together, and this is not really a burden.
Correct.
Okay, it is something that will be helpful for everyone, but it'll also be interesting for us to work on as a project.
Yeah. Yeah, same. I think we are in the same boat there. I'm going to switch to how are we, like if I look at, switch to a question which we talked about briefly before this thing is, how are we looking at this as, if I look at a bank, for example, which might have 500 journeys, and each of those journeys will have different types of notices that you need to put in. for stock and flow. How one of the questions that all these fiduciaries are toying with is, hey, look at this consent. It just, the granularity of the consent is onerous. Is there consent fatigue? Will users drop off because they're kind of having to read this? How would you think about it from the law perspective, and where is the trade-off between, let's say, consent, the fatigue of consent, and doing the right thing?
See, and I'll start with a story here. When we were traveling with Justice Sri Krishna across the country,
Yeah.
and we were trying to understand what the common man, what all stakeholders around India
Yeah.
have to talk about as far as grounds of processing is concerned.
Correct.
And we realized that this heavy preponderance that we are putting on consent
Yeah.
is quite useless,
Yeah.
especially for a country like India.
Yeah.
Okay, large illiterate population, people speaking varied languages.
Yeah.
Even the most educated people are not reading what they are agreeing, consenting to.
Correct.
Now, if you add more granularity there, you are only adding more trouble.
Exactly.
People would be more fatigued and therefore would be reading nothing.
Yeah.
Okay. There were various solutions which were thought of. For example, can we have pop-ups?
Yeah.
Just like you have when you're going on the road and you say turn right, don't turn left. There's a signage there. Can we make people aware in that manner,
Yeah.
where people are compelled to look at it and act accordingly at that juncture?
Yeah.
Right, which will be really meaningful consent.
Correct.
By the way.
Correct.
So I think the way to go forward with this is, of course, we have to see that the principles of the act are baked in.
Yeah.
At the same time, we should be innovative as to how do we want to present this to the end user, the consumer, right? Businesses will always say, or tech team will always tell you that, listen, do not have too many of those sticks and friction areas where the drop rate increases. I think the intent of this recrafted law was that innovation, entrepreneurship, and ease of business should not suffer. At the same time, we need to protect the personal data. Right? That was the real ethos with which we recrafted the law. Keeping that in mind, if we are devising smarter methods of taking consent, meaningful consent, where people are understanding what they are consenting to, but not have, say, too many friction areas and too long a bit of a prose and poetry written about,
Correct.
How consent is being, what this entails. I think we can still find a solution. I'm a very optimistic person. I have tried telling clients also by now that, listen, legal ease is important, of course, in some areas, but some other places we can tone it down. We can make it more layman friendly.
Yeah.
Okay. In fact, in my presentations to most of the boards, to even the last person on the floor, there is hardly much of law that I talk about. This helps in, and I talk with simple examples, relatable examples. Okay. This makes it such easily absorbable concept from a board of director to the last peon who's attending that session. It's unbelievable. So I think likewise for our notice and consent, we should try to take that kind of approach.
Yeah.
We bring in the elements, but we ensure that we craft it in a manner which is understandable easily.
So one of the ideas that at least we are doing it with the product, after this complaint that I heard from a lot of our fiduciaries is, you can actually break down that consent into biteable chunks and present it at different times of that experience that the person goes through. For example, you've got this thing for market, let's say permission for marketing. Don't ask him upfront to do 15 other things, right? You can do it at the next time he logs in. You can ask for one additional thing, which then builds on top of the consent. So the consent is like actually a set of 15 consents you're getting for different pieces. It doesn't have to be one big giant sort of message that shows up at the end of a journey. That was one of our ideas that we had.
Excellent point. In fact, I was advising one of the clients and recently, and the point was that for telemedicine, where
Yeah.
certain consent specifically needs to be
Correct.
taken. Now, when someone is getting onboarded onto the app,
Yeah.
the first plan of the tech team and the business team was let's put everything there.
Correct.
And that was, of course, creating more friction.
Correct.
My simple question to the client was all the people who are coming on board to your app,
Yeah.
are they all going for telemedicine,
Correct.
teleconsultations?
Correct.
And the answer was no.
Correct.
I said, can we have this particular
Exactly.
consent, which is more informed consent because it's more critical, taken at that juncture? And the answer was yes. And so we just moved it away.
Exactly.
Right? So, and there are many such examples.
Yeah.
I can keep talking. I'll tell you this one very interesting one, and maybe then we can move on. So, you would remember there was this one example given in the previous version of the DPDP Act, where it said that you have gone to, say, a shopping mall and there is a restaurant you want to go to, and the person says that there's no space, and please give me your mobile number. I'll call you once the seat is ready.
Correct.
So you give the number. You need not be shown a notice and consent because you've given it for that particular purpose.
Correct.
Which is the
Correct.
other ground of processing or for specified purpose.
Correct.
But if that guy at the end of the day takes that whole list of people and their phone numbers and give it to their marketing guy, that is not permitted.
That's right.
Okay?
That's right.
For that, consent is required. So the question was by one of the clients who had come that can we not use it? I say that listen, you have to think smartly, logically. Is there a way to do it right in the right manner?
That's right.
And the answer was there. Like once the eating is done, usually they give that feedback form in a tab.
Correct.
Why don't you clearly ask there?
Correct.
Is the same set of data which will get captured, but in a legal manner.
Yeah.
Right? And people are really happy. So, and this particular place I'm talking about because I personally go there, I used to love the food. And I'm more than happy that yes, if there's any offer, I would
please
like
send
to
it
be
to me.
intimate. And this is the way to do it.
Yeah.
See, so these are simpler things that we need to change as a mindset of people who are doing business.
And what about data minimization? And, because I think one of the things that we noticed was everybody wants all the data for because we don't know what we'll use it for. So let's collect everything upfront. I want to know whether he has a dog. I want to know whether he has his mother is from which city. All of this, right? And I think one of the principles of the act that I saw is that don't take data which you're never going to use or don't intend to use or don't know why you're building it. But how do fiduciaries trade that off between I can play with data and I have all this data, therefore I can do analytics to hey, you know what, I should not take this data, it's not required. What are your thoughts on?
So I think this has been the way of doing business for quite some time, and honestly, many a times people don't know why they have kept that additional data.
Yeah.
Maybe it is not used, or even tried to be used when it has become too old and useless.
Correct.
So, anyways, you're not doing a great deal of benefit to the business. You're creating more exposure. So, the way we look at it is many a times clients come to us for, a policy to be built for data retention. There are two pieces usually to a policy like this. The first part of the policy is telling you the principles, how you should look at the data minimization concept, okay? Because not everything at the end of the day could possibly get captured to the last dot. But if the ethos and the principles are made known, then people would understand the drift, okay? The second part is a more granular spreadsheet of sorts where say it's a regulated business and that particular business requires the data to be stored for X years. Okay? So we break it down. That if it's this kind of data, then these many years mandatorily, etc. What good part is that people have started understanding.
Yeah.
Now, earlier the request that we used to get is, can you draft a privacy policy in terms of use?
Correct.
And we are good.
Correct.
And then we are fully compliant with any data protection law around the globe.
And tomorrow that policy can be rewritten by somebody and you don't know which guy has signed up for what policy.
And they used to think, often the problem was that to make businesses sit down and or even people sit down and understand, sometimes in-house legal also, that listen, this is not for lip service.
Yeah,
Right?
yeah.
What you are writing there needs to be actually implemented. You should we should have data minimization actually being carried out at the back end
Correct.
when you are writing all of this.
Correct.
Okay. Otherwise, there could be a two-pronged problem. One is you have definitely gone wrong as far as what the law is said. Also, there is a contractual liability because through the terms and condition, you have told something which you are not following.
That's right.
Right? So, I think the good part is now when we get requests, there are more granular aspects like can you also help us with a policy for data retention. This has been, I think, a bit of a sea change, I would say, as far as the mindset is concerned.
And how do you think of, okay, there's one part of consent, which is the notice and the checkbox that you give. The other part of it is processor management and how do I manage all my processors, because breach of, if the processor breaches data, that's the fiduciary's responsibility. There's this whole point about auditing and making sure that you are continuously compliant. Now, how do you play as a fiduciary all these different angles, and what are your thoughts around the fight between the fiduciary and the processor that's going to come up, which is one for example, at least from our side, which we continuously say is unlimited liability, right? Everybody now is going to pass on liability to the processor. The processor might be a 10 crore company and the liability might be 950 crores. That liability clause has no meaning, right? But how do you think fiduciaries should look at it as a legalese problem? Obviously, there will be some of that, but what do you think is in terms of audit, and how are you thinking about it?
The way I would look at it is, of course, there is a responsibility or liability which has been put on the data fiduciaries, which is data controller. And nothing has been written in the context of processor. Therefore, people think that ordinarily, if I write that you are responsible for everything, and you know, one line maybe indemnity clause, that is good enough for me.
Correct.
Trust me, in the Indian context, even to take out 1 rupee in indemnity is a bit tiring. But coming to the actual solution, what can we really think of as a solution? It is a 360-degree approach, starting from a more intense due diligence on the counterparty, especially where you are parting with, say, more sensitive nature of personal data.
Yeah.
Okay. Simple example could be payroll guy.
Yeah.
Okay, where you're giving them all your employee details and the salary and everything. So you have to ensure that you have done proper diligence on that guy. It's not like two people sitting in a room and they have no sort of security or understanding of data privacy, etc. And so that's one. The second thing is that what all should I put in this contract, minus of course my indemnity provision. Does that guy have enough, say, cyber insurance coverage? Do I need to look at things like bank guarantee, depending on what's the situation, bank guarantee or hold back and things like that, so I have better grip over that person. Regular audit reports being shared, at least where my data is concerned. Okay, do I have the right to audit that guy? Things like those, because at the end of the day, I will have to prove, say, in front of a data protection board or it's a TDSAT or a Supreme Court, have I demonstrated compliance? I did not sit tight. There's so many organizations who say that, listen, I don't have time to do any of those other things, no due diligence time, etc.
Correct.
One clause is good enough. Now, if you are having that mindset, as at least for your more sensitive nature of personal data that you're parting, then anyways there's a red flag.
Yeah, agreed. And I think we covered this bit as well. Like the conversation kind of flowed, so I'm moving away from the questions that I've written here.
Absolutely, I think we've always talked like this.
Right. Should fiduciaries wait? I know the answer to that, but what are your
my suggestion on that is, of course, many people will say, you know, how do I dot the I and cross the T exactly the way the rules ask me. I think the GDPR experience had shown us that the 2 years that was given was not sufficient for even the EU organizations who were almost there, like they had a law already. It was one step up. We are going to take a quantum leap. Some people say, what time, say 12 months is given, 18 months is given, take it from me, it will not be sufficient. So what can we do? A, of course, knowing our past does not require me to see the rules.
Correct.
What have I been doing in my organization
Correct.
till now with data doesn't need me to see what rules are coming up in future, right? That's number one. Number two, I think we have reached a global gold standard level anyways.
Yeah.
Many organizations are operating across jurisdictions, and we know what could be a defensible strategy for good data governance
Yeah.
related practices. Now, again, that can be easily brought into play without the rules. Of course, once the rule comes, you might have to do a bit of delta, the check that you want to see, okay, what is the finer nuance I want to carry out. But if you had nothing,
Yeah.
and that day you're trying to take that quantum leap and become all compliant, it may not happen.
Yeah, I think the real problem for a lot of large enterprises is there are these multiple departments. One department saying that I need this data, other department saying no, you don't need this data. There's this internal confusion which I feel is the reason that they're not able to take a call. They're like, oh, then let's wait for the rule because then I know how to justify this internally, right? Because I kind of feel it's more organizational politics, which is stopping people from moving forward because they know it's coming, but probably nobody's listening to the CISO saying it is coming. They're like, let it come.
No, I completely agree. And somewhere in the Indian mindset,
Yeah.
we have seen it for quite some time now.
Yeah.
Especially with this law, we say that okay, let the draft law come out, and then it was like okay, let the act get implemented. Now it is let the rules come in. After that, probably you'll get to see that let the implementation timeline come out. Some could also then go ahead and say let some people get penalized, and then we'll
Correct.
look into it maybe more
Correct.
seriously, right? The way probably to look at it is a more serious approach from the top level, which I think has started occurring in certain pockets in some organizations, where the board is passing down the message very clearly that listen, we have to be serious about it. Start the process, start the action now. So I think the people who are starting now will definitely have a better advantage
Yeah.
to be more compliant.
And if I were to think of like I mean, a lot of our customers, we've been fortunate to be alive for 13 years and seen through I mean, I read the original bill or act that was there as well. Like and I do think the act that I see today seems to be like it's an implementable act. It's not too onerous on any one side. I do feel a little bad that some of the stricter things on that the original act had isn't there, but I think some of them were anyway might have been harder to implement and it's better to move forward than to wait and keep discussing. But considering the act is here and it's already passed the parliament thing, I think it's already a law. Like why wait, right? Why wait for rules? It's what to do. It's very clear. The rules are not going to significantly change any understanding. So that was our take, is that you know that data minimization has to happen. You know that there's going to be breach handling which you'll need to do properly. And when a breach happens, you'll probably have to answer in 3 hours. Do you know where the data went? Like, who all has the data in your org? That itself is a exercise that you'll have to do.
No, I completely agree. And this is just my personal take. For each and every element of the act that has to now come into the rules, further enunciated through the rules, I don't think that probably there'll be a lot of granular detail.
Correct.
Okay. It could be, again, to some extent at a high level.
Correct.
It is nudging you to do the right thing.
Correct.
Rather than telling you exactly what has to be done, right? So again, the dotting of I's and crossing of T's is up to you to be doing. So at a principle level, if you've understood, and I think with GDPR, etc., being in play for so much time, the ecosystem more or less understands what is the right thing to do. Better would be if we can start going down that route and encouraging our system to move in that direction.
On the question on GDPR and DPDP, what do you think companies which have done GDPR implementation, do you think is done, what is the unlearning that they'll have to do?
No, a very good question. And actually, we have met several organizations who think that, so they think they're GDPR compliant, by the way. When I speak deep further, we realize that maybe they just think about it. It's not completely true. But assuming that you are GDPR compliant, like every jurisdiction, there are a lot of differences.
Yeah.
And I believe that similarly for India, there are a lot of differences, deltas which are there, which unlearning or recalibrating or special avenue has to be made for the India business. Okay.
Yeah.
Starting from, and I take very rudimentary examples. Okay. For example, age of consent is 18 years, like
Yeah.
the age of child that is mentioned. It's 16 years under GDPR, can go below up to 13 years depending on the member state. And so you'll have to look at that, right? Maybe you'll have a strictest of the lot approach and try to keep it at 18, whatever. So then there are others very nuanced aspects, say consent manager, right to nominate, right? So
Parental consent, which in GDPR it says I'm over 18. That's it.
So therefore, point is there are a number of such thing. In fact, we've written an article, I've co-authored that, and what I've tried to do, it's on the IAPP platform, is that for each of the provision, if you click, you will see what is the difference, right from applicability to definitions to, some of these nuanced provisions. So it's easier for people to understand, see, there are differences. And differences where implementation and actually putting into play will be different. So you cannot brush it under the carpet saying that we are GDPR compliant.
Correct.
You'll have to be additionally compliant with these requirements.
I think this was a great conversation. One last question. With DPDP coming in play, there's this huge market now for lawyers, for tech providers like us, like for privacy professionals, for audit. What is the one message that you would leave for all of us who are now going to? There's completely a new industry that has been created, right? Practically, in the privacy space, and I think it's going to get a lot more serious than what it was before. So, what is one word of advice?
The only one word of advice that I'd like to sort of convey, and I started off with that why did I get excited about privacy? I think ultimately all of us who are in this particular space should think of the entire ecosystem, India at large. Okay, of course we will do work, we will do business and all of that. But at the end of it, if we are able to make this country a more mature ecosystem as privacy data protection is concerned, I think that will be our real, I would say, takeaway. We would really feel good about it, that this is what we did at the end of the day. Of course, other than doing a particular profession in a good manner or a business in a good manner, I think that will be the best thing.
What a great conversation, Supratim. I loved it, and these cards were of no use. but because the conversation naturally flowed into areas, I think we covered most of what I wanted to cover. So, but thank you for coming.
No, thank you so much actually for inviting me. Always a pleasure to be speaking with you. Thank you so much.
And thanks everyone for joining us, and bye.